We're live.
Morning. This is Senate Judiciary Committee, March 3rd, 2023. We're taking up H16, an act relating to repealing the exemption for clergy to report child abuse and neglect. We have with us this morning Bishop of Vermont, and we welcome Bishop Coyne to the committee, and thank you for being here in person. Sorry that many of us, due to COVID, are remote this morning. Thank you for being here.
You're welcome, State Senator. My name is Bishop Christopher Coyne. I am the Bishop of the Catholic Diocese of Burlington, which encompasses the whole state of Burlington, Vermont. I am here, thankfully, thanking you for allowing me to testify. I'm here principally as a pastor and people of faith, not as a politician and not as a lawyer. So I just would like to speak to the matter as regarding the worship of the church in terms of the celebration of the sacrament of confession. First of all, I don't represent any other religious denomination, but I will say presently all clergy and lay employees of the Diocese of Burlington for the whole state are mandatory reporters. Anyone who works for the diocese or its parishes must have a criminal background check. If they work or interact with minors, they have to have virtus training, which is our safe environment training, including recognizing the signs of the child suffering from neglect or abuse. So we are mandatory reporters. We follow all the laws of the state of Vermont as regards that. The conversations that we have in our offices, the counseling sessions that we do, spiritual direction that we do, none of that is privileged, and it's all included under the mandatory reporting statutes. The sacramental exemption for the sacrament of penance is very narrow. It is limited to sacramental penitential communication. Requiring clergy to report child abuse learned during a penitential communication would infringe upon our First Amendment rights. And not just the rights of myself and the clergy, but the rights of all of the Catholics in the state of Vermont and the rights of any other faith community that has that kind of a privileged penitential communication. Though priests do provide counseling during their ministry, sacramental confession is an entirely different encounter. The celebration of the sacrament of confession is part of the church's official worship. It is not a counseling session, nor a simple moment of prayer. It is the official worship of the church. And as such, it's covered by this book that is promulgated and given to us out of Rome, translated into English, and used in every church in the United States. It's a moment that is directed and maintained by the church. It's the official worship of the church. It's a time in which people of faith come together and worship as such in the liturgy of the church. As such, sacramental confession is a moment of worship in which the penitent seeks God's mercy and forgiveness for what they have done. The priest is there for their sake and as a mediator of God's mercy. The priest has a sacred duty to maintain the secrecy of sacramental confession. That means from ancient times, if a king approached a priest and made confession, that confession could not be shared with anyone else, even if it was to the advantage of the church or the priest at the time. And it goes right down to today, where the President of the United States could go to confession to a priest and would not have to worry about being subpoenaed by the Congress, the priesthood, to in many ways expose what was said to the priest in confession. The priest is there for the sake of the person. Even if a penitent waives the privilege, we would not be allowed to testify or make public what was said. A priest faces excommunication if he discloses a communication made to him during confession. And the sacramental seal of confession is the worldwide law of the Catholic Church, not just the Diocese of Vermont. No bishop has the authority to change this. I cannot change this. I cannot remove it. I cannot say that priests have a right to do that. So we oppose S16 because it crosses a constitutionally protected element of our religious faith, the right to worship as we see fit. There is no question that protecting children is essential and criminals must be held accountable for their crimes, but disregarding fundamental religious rights is unnecessary. The sanctity of religious communications can be protected and respected, and criminals brought to justice for their crimes. The two public priorities are not mutually exclusive. Thank you for your time.
Apologize for being late.
That's okay.
Not seeing any questions.
Thank you, Bishop. I guess my first question is, in our look at other states who have such exemptions or don't have an exemption, and New York comes to mind, and I'm not sure exactly how New York's law is different from what's proposed in S16. My understanding was that there is no exemption there in New York. Do you know any? Do you have any information on that?
Senator, from what I understand is that the numbers that were given in the AP article were erroneous, that in fact, the only state that appears to have something close to an exemption for the privilege of sacramental confession is Texas. And that's still unclear as to what that means because it does not specifically state or apply to the question of penitential communication. But even in New York, the penitential communication is still privileged.
Thank you. Yeah. I'm hopeful that we can research that before we move much further forward with the bill. Are there other questions for the bishop?
Yeah, just a couple. Thank you for being here, Bishop Coyne. So there's no other states throughout the United States that you're aware of that have the carve-outs in this particular bill that's being proposed as far as.
That I'm aware of, yes.
Okay, so even if this bill was to pass, it is of your opinion that priests throughout the United States or Vermont, more importantly, still would follow the church's penitential rights and so on and so forth as far as canon law, as far as the confidentiality of penance coming in and offering their.
All priests have a sacred duty to maintain the seal of confession. And so I'll leave it at that.
So I find that having said that, I find that sometimes I wonder as to what this may or may not achieve through this Senate committee, due to the fact that if in fact it did become law through this House, it's almost like you want to wonder how many folks are going to line up for confessional, knowing that all of a sudden the priest, it won't happen, but the priest now will be able to report any criminal actions to law enforcement. I can't see a whole long line of people lining up for confession on those particular circumstances. That's just my take on this. And basically, such as I've said before, is even if they become law and they chose not to, how would we ever know that there was confession made? So it appears as though, although the intent may be good in this particular case, because nobody wants our children abused or whatever else, I can assure you, and I agree with that. But the fact of the matter is, it's a false protection, it's a false security as far as what I can ascertain from this. So having said that, I want to thank you for coming, Bishop.
Well, that definitely Senator Norris is part of the debate. It may in fact be, but when you have child sexual or physical abuse and you're a mandatory reporter, I wonder what that does to the individual hearing that, and maybe the bishop could speak to how it is for a priest to hear that. And maybe I'm not completely understanding, but the person is asking for forgiveness from something that is abhorrent. And I don't know how what does a priest do with that? They can't even talk with the bishop about it? I guess that's my question.
No, the priest cannot reveal in any way, shape, or form what was conveyed in confession, most especially involving a particular person. And you have to be doubly careful to not speak to in a matter that may perhaps lead to someone to suspect a person or have someone, for example, think that we're talking about them. So if I were to be in front of people and if I were to say something like, I heard a confession recently in which the person said this, and I might be referring to a confession that I heard in Texas, for example, or any other state, but not to the local place. But there could be a person in front of me who would say, well, gee, I went to confession to him and I talked about that exact same thing, so he must be talking about me. So just to kind of get away from that kind of example, it's just that when confession is over, it's over. You can't talk to the person about what took place in it. Afterwards, they could come to you and say, can I talk to you about what we talked about? And then that would go into a kind of confidential conversation. It's not an automatic forgiveness telephone booth. When a person comes in, they truly have to be penitent. They truly have to be seeking to change their lives. They have to be willing to move it in a direction. And if there is something that involves a criminal nature, the priest could also say that you have to do something about this. You need to approach the authorities. You need to do something. But it's on the person then at that point. And if there's an obvious situation in which the person is not sorrowful and does not intend to correct their behavior, then they're not given the forgiveness of the church. They leave without absolution, as we say. So it's not a free kind of. It's not just to kind of use the monopoly phrase. It's not a get out of jail free card. It's a sacred right in which the priest is the mediator between the person and God and seeks to help them find their way to forgiveness and God's mercy. But we're not there as counselors. We're not there. In fact, we train, you're not there for counselors. If they need counseling, you suggest counseling. That's what we do. But we are mandatory reporters, and any heinous action against a child, any abuse of a child, as this bill says, whether it's done by clergy or done by laity, outside of confession, is reported by us to the police, to the state police, to the Department of DFC or DCF. What is it? DCF. And we've been consistent with that since all this started back in 2002.
Well, thank you very much. This is very helpful to me in helping to understand the role of the confessional.
You're welcome.
My wife, who's Catholic, never really explained it to me that well. So.
Well, we have the adult education down in your local parish if you want to come. There's some time.
That might be helpful. Are there other questions for the bishop? Again, thank you so much for being here. Appreciate it.
You're welcome.
Very helpful.
This was easy. I hope my testimony's been helpful.
It has. I believe our next witness is Monsignor McDermott.
Actually, I was just here to provide support and answer any questions by way of canon law, if there were any. So I really don't have anything that I could add that would add to what the bishop has already said, except to say that as a priest, I have a sacred duty to uphold the seal of the sacrament, and it will be upheld.
Just out of interest, when you come across the child abuse that is not part of the sacrament, is it clearly reported, and maybe some examples of how you might have come across some of that?
Are you asking myself, Senator? Or are you asking Monsignor?
Yeah, either the Monsignor McDermott or Bishop.
In regarding to if we're hearing of cases of sexual abuse of minor or neglect of a minor outside of confession, we have, for the last almost 20 years, I've worked at the Chancery Office and been involved with the Safe Environment Program since 2002. So we're trained to report to the appropriate authorities. I've, on a regular basis, working with our Safe Environment coordinators over the years, have had to make reports to the state when information has come about neglect or abuse of minors. So it is very clear, and we have regular updates to our clergy and to our parish personnel to say, if you learn, and even if there's a doubt, we always say, report it. Better to report when you're uncertain as opposed to not reporting. So we've had those conversations very regularly over the last 20 years. I mean, it's not a flood of, thankfully, it's not a flood of calls or concerns, but it's something we take very, very seriously. Yeah, and we have a independent review board with mostly lay members that I meet with quarterly to review our policies, but also in the event that we have needing advice or recommendations, we seek their advice.
Thank you. That's helpful. Do children come forward from time to time to report abuse?
Well,
And I'm not talking about any
they don't
confession.
come forward. As they begin to tell you their story, you realize that the child is being, that there's abuse going on. They don't necessarily come to us or a teacher and say, I'm being abused, but our teachers and our staff know the signs now, in schools especially, but usually when you're speaking to a child, they'll tell you that my mommy and daddy are they hurt me or something like that, but they're not trying necessarily to be reporting. It's just a child speaking out of their woundedness.
Thank you.
I think that's, again, where our safe environment program, trying to train people to recognize signs of abuse or neglect and be able to take the necessary and proper steps to make sure our children are safe.
That's helpful, very helpful. Other questions for Monsignor McDermott? Thank you both very much.
Senator Sears?
Yes.
If I might.
Yeah, please, Senator.
Not a question so much as a statement of the problem that I think we're facing. So, you know, men of good faith, you come forward and you tell us that in the church, in any area outside the confessional, you have robust programs to stop child abuse. But if a parishioner came to you directly in the confessional and said, I am abusing a child, the most that you might help is to deny them absolution. Other than that, there would be no aid for that child. And I think that's what people struggle with who are outside the faith. The core of the faith, the sacrament that you're talking about, would in that case act in no way to protect the child who is the helpless parishioner. And I struggle with a bill like this, how we would keep faith with both your sacrament and that child. So that's the paradox for me. And I want you to know that we'll discuss it in good faith and at great length. But, you know, my own heart goes out to the child who the priest now knows is being abused, but will not report that abuse. And yes, will deny absolution to the person who, as I think you said, Bishop, a person who is unrepentant and is going to go out, they will not receive the relief that the church can offer, but otherwise there'll be no action taken.
Perhaps
is that correct?
It would be correct, except in order to understand another added challenge or difficulty is that the vast majority of the time, confession is an anonymous celebration.
Mm-hmm.
You don't know who's going to confession.
Mm-hmm.
You don't see a face, there's no sign in. So if someone were to come in and confess that, even if we wanted to, what would we report? No name, no child name, no anything. There's nothing to report to say, except to say someone is being abused.
Yeah, I am no expert in your rituals. I'm speaking as somebody from outside the Catholic faith who has struggled over the last couple of decades to understand certain aspects of this problem. So I just offer that as my own rejoinder to what you're saying.
I would think I speak for the bishop and every
We
priest.
also, we can urge them they have, when you leave this place, you have to do something about this. You have to get away from that child. You have to get the counseling. You have to do something. If they go to counseling, of course, then they'll be reported. But we don't just say, do anything about this. And it is heartbreaking. And then I've never, I was about to go to a place I can't go. But sometimes when you can't do something about something that you hear professionally, it is heartbreaking.
Well, thanks both. Nothing else. Thank you.
Thank you. Thank you, senators.
Thank you both very much. Our next witness is Reverend, is Reverend John Paul Kimes, Associate Professor of the Practice at Notre Dame Law School.
Sorry.
Is
Senator.
Mr.
Thank you.
Thank
I
you.
apologize for joining a little late, so I missed the beginning of the
No,
bishop's presentation.
That's fine.
I've prepared kind of a written
Thank you
statement.
for being with us today,
Yes.
remotely, and it's much easier than lying here from Notre Dame, I'm sure.
It's my pleasure. I would have flown out gladly had I had a little more time to prepare, but I'm happy to join, and it's a privilege to talk to you, to speak to your fellow senators in the State Assembly about Bill S-16, which, as you know, seeks to, in its own language, repeal the four-pronged exemption that permits clergy not to report sex abuse and neglect when it's received in confidence while acting as a spiritual advisor. I'm happy to read through a prepared statement or respond to specific questions about canon law, however you'd prefer to proceed, Senator.
Well, I'd love to have you read your prepared statement, and then if you can answer questions that may have come up or expand on what Bishop and Monsignor have just told us. You may not have heard that, so, but at any rate, we can do questions afterwards.
Well,
Please.
thank you very much. As I said, well, I'm not an expert on constitutional law. I'm an expert in the canon law of the Catholic Church, but this context of the priest penitent privileges is generally referred to in civil law raises with Bill 16, there are certain concerns that are raised that would overturn this institution of the law that has been at least part of our American tradition since 1813. But before addressing those specific legal issues, just a moment about myself, that it's incumbent upon me to speak about the commitment of the Catholic Church, both in the United States and around the world, to protect children from abuse, whether that abuse is perpetrated by clergy or any member of society. I spent 11 years serving in what is known as the discipline section of the Congregation for the Doctrine of the Faith, which is the tribunal of the Catholic Church in which every case of clergy sexual abuse is tried in one form or another. In those 11 years, I was part of the prosecution of more than 2,000 cases of sexual abuse. So I have lived the Catholic Church's commitment to protecting children and to prosecuting its offenders firsthand for most of my priesthood and all of my professional life. In the year 2002, the bishops of the United States of America met together in the city of Dallas, drafted a document that has become the gold standard for protecting children in religious institutions. This document, known as the Charter for the Protection of Children and Young People, commonly referred to as the Dallas Charter, established the first ever zero tolerance policy, that no clergyman in the Catholic Church who is convicted of a single action that would constitute sexual abuse of a minor would ever publicly function in the Catholic Church again. No other organization has taken this strong of a stance against the presence of those who would harm children. Not the public schools, not the medical profession, not the legal profession. It was a very hard and painful lesson that the Catholic Church learned about the tragedy of sexual abuse, but it is a lesson that has been learned, and the Church has both legislation and practical policies that reflect this one-of-a-kind zero tolerance of sexual abuse of minors. And while I seriously doubt that anyone would like an excursus into the history of Catholic legislation, I'm happy to provide more historical data on that if necessary. But regarding the topic addressed in Senate Bill 16, in the Catholic Church, there are different kinds of communication between laity and clergy that are protected by different levels of confidentiality. The one that most people are familiar with, and the one that the bishop spoke about earlier, Monsignor McDermott spoke about earlier, and the one that is most challenged by this legislation is what is referred to in canon law as the sacramental seal. The church's current legislation, Canon 983 of the 1983 Code, states quite simply, the sacramental seal is inviolable. Accordingly, it is absolutely wrong for a confessor in any way to betray the penitent for any reason whatsoever, whether by word or in any other fashion. Here, the English translation does not entirely convey the gravity of the matter. In the original text, the term nefas is used to describe how this violation, this betrayal of the penitent, is to be considered. There is no term in the Latin language that more strongly describes a prohibited action than nefas. It is an abomination. It is an atrocity. In its nominal form, the term means wickedness. The term is only used 4 times in the Code of Canon Law, and always in relation to violations of the most sacred teachings of the Catholic Church. This just to tell you how seriously the Church views this sacramental seal and how rarely it reserves this level of language for violations of sacred things in the Catholic tradition. But lest anyone have the false impression that the sacramental seal is a tool designed for hiding specific information or covering up the crimes of clergy, the legal teaching of the Catholic Church that the sacramental seal is inviolable dates back at the very least to the 10th century. It is recorded by the author Gratian, who is known as the first compiler of canon law. Prior to him, all canon law had been recorded in literally thousands of different documents. Gratian's life work was to compile these documents into a single volume so that the law of the Catholic Church would be accessible. This took place in the middle of the 12th century. Just before then, the Fourth Lateran Council in the year 1215, which is the very same year of the Magna Carta, this Fourth Lateran Council repeats the prohibition against the possible violation of the sacramental seal. Canon 21 of the Fourth Lateran Council from the year 1215 reads as follows: let the priest absolutely beware that he does not by word or sign or by any manner whatever in any way betray the sinner. For whoever dare to reveal a sin disclosed to him in the tribunal of penance, we decree that he shall not only be deposed from priestly office, but that he shall be sent into the confinement of a monastery to do a perpetual penance. No penalty for any crime mentioned in that piece of legislation, the Fourth Lateran Council, is more severe than the crime reserved for the violation of the sacramental seal. But neither Gratian nor the documents of the Fourth Lateran Council speak about this prohibition as something new. Rather, it is described as something that is already known. These prohibitions are mere repetitions, dating the understanding of absolute confidentiality of the seal to a time lost in history. Before discussing the consequences that a Catholic priest who might violate the seal would face inside the Catholic Church today, allow me to share a brief thought about the way the bill addresses the question of clergy confidentiality and child protection. It appears that the fundamental belief behind this bill is that children cannot be protected from abuse and neglect unless clergy are forced to violate confidential communications. This binary approach does not, in my opinion, reflect the reality of the situation. As a Catholic priest, there are always things that I can do to help a victim of abuse or neglect outside of the confession. I can protect the sacramental life of the Church and children at the same time. These two goods should not be seen in binary opposition as they appear to be proposed in the current legislation. But why, for Catholics, is this seal so important? In Catholic theology, there is no moment in the life of the faithful in which they are more spiritually vulnerable than in the act of confession, when we take our deepest secrets and lay them bare before the priest who represents Christ. It is a moment of supreme spiritual intimacy. We use the term confidentiality a lot in our society, but sacramentally, the seal goes well beyond any civil notion of confidentiality. The seal is only defined as being inviolable. With a confidentiality requirement, there is always a workaround. With the sacramental seal in the law of the Catholic Church, there is no workaround. It is always absolutely inviolable because of the vulnerability of the penitent at that moment and the intimate spiritual relationship that that moment portrays. This vulnerability and sacred trust between clergy and laity is reflected in other Christian denominations as well. In the Orthodox Church, their need to maintain the secrecy of confession comes from the fact that the priest is a witness before God. No one could not expect a sincere and complete confession if the penitent has any doubts regarding the practice of confidentiality. The Church of Jesus Christ of Latter-day Saints recognizes a similar confidentiality between the clergy and the laity. The Lutheran Church of the Missouri Synod states that under no circumstance should a pastor reveal anything to him told by confession by a penitent. Similarly, the Episcopal Church maintains legislation that states the priest may be asked by a court of law to divulge information, but he must refuse even though this may lead to imprisonment. The members of the Christian Science group state that the members of this church shall hold in sacred confidence all private communications made to them by their patients. A failure to do so will subject the offender to church discipline. The understanding of confidentiality goes far beyond the Catholic teaching about the sacramental seal. It impacts other religious groups as well, other denominations who hold this understanding of confidentiality as sacred. Moreover, it is just that kind of vulnerability that is remarked upon in the first decision in the US legal system that addresses privileged conversations. In People v. Phillips, heard in the New York Court in General Session in the year 1813, a Catholic priest heard the confession of an immigrant who had knowingly received stolen goods. The priest, Father Coleman, returned the stolen goods to the original owner, who then reported this fact to the police. In this way, Father Coleman was able to both restore justice and protect the confidentiality, the inviolability of the sacramental seal. The court, however, subpoenaed Father Coleman after the original owner reported the theft to the police. They sought to have Father Coleman testify about his knowledge of the theft. The court eventually decided that the only course for the court is to declare that Father Coleman not testify or act at all. In this decision, the court made the following remark, quote, "It is essential to the free exercise of religion that its ordinances, that is, of the church, should be administered, that its ceremonies, as well as its essentials, should be protected. The sacraments of religion are its most important elements." And here the judge uses language which will strike us as odd in the 21st century, but in 1813, this was very common. The judge writes, "We have but two sacraments in the Protestant Church, baptism and the Lord's Supper, and they are considered seals of the covenant of grace." He continues, "To decide that the minister shall promulgate what he receives in confession is to declare that there shall be no penance, and this important teaching of the Roman Catholic religion would thus be annihilated." End quote. These are the words of a judge in New York in the year 1813. The United States Supreme Court took up the issue in 1875 in the landmark Tottenham versus United States case. In its decision, the court stated the following: "It may be stated as a general principle that public policy forbids the maintenance of any suit in the court of justice, the trial of which would inevitably lead to the disclosures of matters which the law itself regards as confidential, and respecting which it will not allow the confidence to be violated. On this principle, suits cannot be maintained which would require a disclosure of the confidences of the confessional, or those between husband and wife, or of communications by a client to counsel for professional advice, or of a patient to his physician for similar purpose. Much greater reason exists for the application of the principle to cases of contract for secret service to the government, as the existence of a contract of that kind is by no fact to be disclosed." End quote. The history of the Anglo-American legal system includes a strong understanding of the importance of the priest-penitent privilege in the courts. It is a respect for religion that is enshrined in our Constitution. It is a respect of religious practice that has been repeatedly upheld by the United States Supreme Court. Now, to speak briefly in closing about the consequences for a Catholic priest should he violate the sacramental seal, I can speak personally from experience, having prosecuted priests for the crime of the violation of the seal, that they are subject to the most severe penalties the Catholic Church has, including dismissal from the clerical state. That is to say, that a priest who violates the sacramental seal risks never functioning in public as a priest again. This crime is taken very seriously by the Catholic Church and has been for more than 1,200 years. To force a priest to violate the sacramental seal puts him between a choice of maintaining his religion, of maintaining his position within his religion and not violating the precepts of his faith, and violating civil law. Before that choice, the Catholic priest will keep the tenets of his faith and will violate civil law. There's a long history of priests who have been martyred, who have suffered death at the hands of civil authorities in order to maintain the sacred bond of the sacramental seal. I trust that the Assembly of the State of Vermont will not put the Catholic priests of its state before the same choice. Thank you.
Thank you very much, Reverend Kins. A very concise history of both the Catholic Church and other religions in terms of this. Are there other states besides Texas that have limits?
So there are 33 states that have protection, that have express protection on the sacramental seal and other confidential communications between clergy and the faithful of different religious groups. There have been attempts, as I'm sure you are well aware, in Utah and in California to enact bills similar to the bill being proposed now in Vermont. In both of those states, both in California and in Utah, those bills have failed to progress through their senates after hearings about similar to this one. So my hope is that in following the example of the legislature in California and the legislature in Utah, that the testimony provided today will provide evidence and convincing arguments to the State Assembly in Vermont that there is another way to move forward that would not create a conflict between the principles of religion and the protection of children and vulnerable people.
Appreciate that response. So the other states that don't have anything specific, like Vermont, which currently has a specific exemption, aren't necessarily allowing, aren't forcing priests or other denominations to provide the information. They're just silent on it.
Yes, sir. You have the most recent example in 2014 from the Supreme Court in the state of Louisiana, a decision which was later vacated based on the based on federal constitutional principles, that it was that the decision of the Supreme Court of Louisiana created a conflict in law that was resolved by a higher court. But that would be the most recent example of a state that sought to impose upon priests, again, not only Catholic priests, but clergy in general, this that sought to remove that privilege and impose sanctions were they not to violate confidentiality.
Appreciate that. Other questions for Reverend Kim? I thank you very much for making time in your busy schedule for us this morning. It's very helpful.
My pleasure. Thank you for the opportunity.
Welcome. Our next witness is, sorry, I have to go back online. Thomas Borchardt, Professor and Chair, Department of Religion at the University of Vermont.
Good morning.
Good
I'm
morning.
assuming you can hear me? Yes.
Yes.
Okay, great. Thanks for giving me the opportunity to speak to you this morning about the exemption for members of the clergy as mandatory reporters in 33 VSA 4913. I'm speaking this morning from the location of religious studies. My discipline is concerned primarily with the way that phenomena we call religions work in society. In other words, we don't speak from a particular religious community or sectarian position, but seek to understand what religions do, how people within the statements, practices, and institutions that generally comprise the things we call religions. One of the things that we spend a lot of time doing, especially in classes, is interrogating the meaning of the word religion. It is a particularly interesting and vexing term because on the surface, its meaning is clear. We all understand what religion is, presumably, but it doesn't take long to understand that groups of people, religious actors, religious institutions, governments, academics, media, everyday people, define the word religion in very different ways. Some of these differences are large, some are quite small, but it has an impact in shaping what we consider religion and how we interrogate it. Now, my primary expertise is in the religions of Asia. I conduct research among Buddhist monastic communities in China and Thailand, examining the education and training of monks, their self-understandings as both religious and religious actors and citizens, and their entanglements with legal pluralism. That is how they are governed by both religious and secular legal systems. These issues shift into my teaching, where I often teach about religious disciplines, religion and law, religion and nationalism in the US, as well as in Asia. Religious freedom is a discourse and practice that I've had to think about a good deal within the last decade for reasons that I imagine you can understand. In considering the clerical exemption in 33 VSA 4913, there are two global points that I would like you to take away, regardless of how you ultimately decide about this bill. One is about the diversity of religious practices in communities, and two, about the challenge of specificity when thinking about religions and laws about religions. First, and I think most importantly, I want you to understand that religious communities and religious practices are incredibly diverse. I'm sure that you understand this generally, but it's a point that can't be emphasized enough. We see an attempt at this diversity, to recognize this diversity, in the definition of members of the clergy in 33 VSA 4912.8, which is the definitions of that are embedded in 33 VSA 4913. And let me read this for you. It says, members of the clergy means a priest, a rabbi, a clergy member, ordained or licensed minister, leader of any church or religious body, accredited Christian Science practitioner, or person performing official duties on behalf of a church or a religious body that are recognized as the duties of a priest, rabbi, clergy, nun, brother, ordained or licensed minister, leader of any church or religious body, or accredited Christian Science practitioner. Now, the language here is broad and seeks to be inclusive, though I would make 2 points. One is it does miss some important categories such as imams. And, so in its kitchen sink effort to define members of the clergy, it doesn't and can't get to everything. The other thing that I think is important is that there are some squishy categories in there, such as the word religious body. That is to say, if we cannot fully define what religion is, if we can't agree on what counts as a religion, and indeed both the free exercise, the constitutional language of free exercise and establishment make it very hard for the government to define what religion is. It's unclear to me how we can also define what a religious body is. So what seeks to be clear ends up being very squishy. However, there's another kind of broader point that I want to make, that in thinking about the diversity of religious communities and practices, our language often lets us down. When we speak about religion or Christianity or some other specific religion, we often have a specific religious community or tradition that shapes the statements or models that we create. That is, one religion, sect, etc., becomes the normal one, the model for all the others. In US history, this has often been Protestant forms of Christianity, And we see this in you know, kind of like in the calendar, the aspects of religious life that are seen as normal for mainline Protestants become part of what is the norm for society, and in some ways religious aspects become invisible and are made secular. That is to say, non-religious. Now, in a lot of ways, in U.S. history, this has been entangled with what we might think of as a lot of anti-Catholic bias, which you know, is of course a significant problem. We see a concrete example of what I'm talking about in clerical exemption, in the clerical exemption of 33 VSA 4913. While the language here is general and generic, I suspect that the model behind it is that of the confessional of the Catholic Church that Father Kimes has just been talking about. In other words, this language normalizes as generic and general a practice that is actually specific to one form of religion. Now, does this mean that the exemption unintentionally creates an establishment issue for the state of Vermont? I think this is complicated, and I don't want to make a claim about this without greater consideration of the history of the statute, for example. But I think that this resonates with other unintentional establishment clause cases that I've read about. When Senator Hashim reached out to my department to invite someone to come speak, he asked me to speak generally about confidentiality and religious specialists. Given the context of this particular proposed amendment to the law, I understood him to be asking me to talk about how religious specialists or leaders, the folks that 33 VSA 4912.8 defines so laboriously, handle specific pastoral moments. When a religious specialist hears something that is troubling, such as the report of abuse, what are they supposed to do about it? Is keeping confidence a core part of what religious communities do, or is it more common to share that information? Is it mandated by religious law? So my answer in some ways, excuse me, is a little bit unsatisfying and pushes against the clarity that Father Kimes was speaking to. I think actually it depends much more, that there's much more diversity than he was speaking about. There is not a single answer about how different religious communities have defined this, because religious communities have deeply different institutional structures. They have different pastoral practices and understandings of the status of those pastoral practice, and they have different ways of intersecting with secular law. The confession is one form, of course, and it's guided by canon law. But if we consider another common form of Protestant Christianity, Presbyterians, they handle this very differently. For example, a 2004 document from the Presbyterian Church USA, Life Together in the Community of Faith, Standards of Ethical Conduct for Ordained Officers in the Presbyterian Church USA, has as one of its statements, quote, "I will conduct my ministry so that nothing need be hidden from a governing body or colleagues in ministry. Therefore, I will respect the privacy of individuals and not divulge information obtained in confidence without express permission, unless an individual is a danger to self or others." And was approved by the General Assembly of the PCUSA in 1998 and published in 2004. So it seems to me that this implies that the standard is generally confidentiality, but when there is a concern with something serious, such as abuse of children, the denomination is saying that we believe we have a responsibility to share it. You know, we can generalize and say that most religious specialists, when engaged in pastoral moments, recognize the importance of confidentiality, the status of that, and therefore the responsibility. But the status of that, and therefore the responsibility of the hearer, also varies widely, and it varies widely within denominations. So there are Presbyterians who I think would situate themselves much closer to Father Kimes than what I've just said. There are Lutherans who again would express a greater sanctity of these pastoral moments than others. And so I worry in a sense about normalizing one form of religiosity in the context of the statute. The second kind of global point that I want to make is about the language of the exemption. I understand that the language is attempting to be clear, but in its four-pronged exemption, but I'm concerned that it fails in this. The first prong of the exemption test is that it is to be made to a member of the clergy in their role as a spiritual advisor. I spoke a moment ago about the problem of the meaning and reference of the word religion, and the same is true of words like sacred and spiritual. They seem to have clear meanings, but when we look at them closely, they can mean very different things depending on the context. This term, spiritual advisor, has a set of meanings that have to do with the history of Christianity, but it also has to do with meaning-making concerns of the post-Cold War U.S. Many of my students describe themselves as spiritual but not religious. And in that context, the things that I do in class, which I would argue are deeply not spiritual, but they may see me as a spiritual advisor. Which would put me in the context of acting in my advising capacity as a spiritual advisor, which I think is not the intention of the statute, but is a possible interpretation. And I could give you some other examples of this. But as a result, while the sentence seeks to define the type of interaction that's taking place, its apparent clarity breaks down fairly quickly when we consider the diversity of religious practices. The second point has to do with the third prong of the test, which is that it is intended by the communicant to act as an act of attrition or a matter of consciousness, a matter of conscience. And again, it seems to me that there are real concerns with this particular prong that come from the discipline of religious studies. A very common way of defining religion has to do with that it is a system of beliefs. But in religious studies, we've moved away from this precisely because most of us do not have access to the internal thoughts of others, just their written and spoken statements, as well as their observations of action. I worry that the language of this statement implies that religious specialists know what is happening in the heart of someone else. It may lead them to be misled, sincerely and unintentionally, to assume that the abuse that is being spoken of in this pastoral moment is done, when in fact they have no idea if it's done. They have no idea what the person is thinking. They only know what they're saying. And so how they can know whether the intention is real and true or sincere seems to me to be a deeply problematic matter. So just to conclude, I do recognize that there are challenges here. There is the potential of free exercise infringements, as Father Kimes has spoken of, though I think there's also an unintentional potential establishment clause with the way that the exemption is written here. But I would also note, and I know that this is not a light matter, that we're talking about something, the abuse of children and other victims of sexual abuse, that we want to create mechanisms for elimination. Religious institutions in the United States and elsewhere around the world, the Catholic Church, the Southern Baptist Convention, the Church of Jesus Christ of Latter-day Saints, Zen, and other Buddhist communities, including some of those in the state of Vermont, have not been particularly effective at protecting victims or alleged victims of abuse, in part because of the kinds of secrecy that are entangled with the kinds of religious practices that we're talking about here. And the clerical exemption makes it more likely for it to be easier for them to be not particularly good partners. So I do not think that this is a particularly easy issue, but I think there are real problems with the way that this exemption is written, and I would actually encourage you to move forward with this bill. Let me stop there because I've spoken for a long time, and happy to answer any questions that you might have.
Thank you, Professor. You actually surprised me with the last statement. So I start there, and you're suggesting we go forward with the bill. And I was particularly struck by the bill as introduced would repeal intended by the communicant be an act of contrition or a matter of conscience. And I guess I would say that even if we didn't repeal the other portions of the law, what you're suggesting is there's no way to know what the communicant's motives are.
I think that is correct. I mean, I can't read people's minds. I only know what they're telling me and what I observe their actions are. I also know that when we think about abuse, and perpetrators, like I don't want to. Perpetrators are engaged in activity that harms others, and I don't think that they're evil monsters necessarily, but I think the intention here is that we mitigate harm and we eliminate the abuse. And someone may be completely they may be speaking sincerely, or they may be lying through their teeth, and I have no way of judging what is in their heart. That none of us in the secular world have the capacity to do that. I have met monks and other religious specialists who claim to have that capacity, but I don't think that is something that's recognized in the legal system of the United States in its various iterations. So I find, as I said, I think the three of the four prongs I have problems. I have a variety of problems with, but that one in particular, the third prong is something that is a real problem.
Thank you. Other questions for? Very clear and very helpful.
Thank you,
Very
Professor.
much appreciate you taking the time with us this morning.
Yeah, my pleasure. Thank you.
Thank you. Committee, Ben, are you with us?
Yes, Senator Sears, I'm here.
Good. It might be helpful. Well, it's 10 o'clock and I believe we have a limited amount of time. Katie at 10:15. So we're scheduled to come back to this at 10:30. Would the committee be okay with a break, but get right back at 10:15?
That sounds good.
And Ben, can you be with us at 10:30? After
Yes, I'll be
Katie's
here.
finished with S89, which is the forensic facility.
Yes, I'll be here.
Okay. Okay, thank you. Mike, would you let Peggy know?